So, Donald Trump's legal team just got blindsided in federal court so badly that they literally had to request an emergency recess in the middle of oral arguments. And let me tell you, the look on their faces said everything. We're talking about a moment where Trump's high-powered attorneys, the ones who have been confidently dismissing charges and attacking prosecutors for months, suddenly found themselves scrambling for answers they didn't have, requesting time to consult with their client, and basically admitting in open court that they weren't prepared for what the judge just threw at them. It's honestly hard to believe we're watching what's pressed as supposed to be America's most experienced legal minds get caught this flat-footed. This isn't just about one awkward courtroom moment or a minor procedural hiccup. We're talking about a development that exposed fundamental weaknesses in Trump's entire defense strategy, revealed internal disagreements within his legal team, and forced them into decisions they clearly weren't ready to make. The implications are massive, the optics are terrible, and everyone in that tie. The courtroom knew they were watching Trump's defense unravel in real time. Let me fill you in on what's been happening because the story behind this courtroom freeze is absolutely wild. So, Donald Trump and his legal team have been fighting special counsel Jack Smith's federal election interference case with everything they've got. This prosecution, brought against Trump in August 2023, charges him with 4 federal counts related to his efforts to overturn the 2020 election, conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. These are extraordinarily serious charges that could result in significant prison time if Trump is convicted. From the moment these charges were filed, Trump's legal strategy has been absolutely clear. Attack the prosecution as politically motivated, delay the trial as long as humanly possible, and claim immunity from prosecution for actions taken as president. Whether it was filing motion after motion claiming presidential immunity, arguing that former presidents cannot be prosecuted for official acts, challenging the special counsel's authority to bring the case, or trying to get evidence suppressed on various technical grounds. Trump's legal team really cemented themselves as masters of aggressive courtroom tactics and procedural warfare. They've made it clear they're willing to push every legal boundary, make every possible argument, and fight on every conceivable front to keep Trump out of the defendant's chair before a jury. But here's where things get interesting. The case is currently before Judge Tanya Chutkan in the U.S. District Court for the District of Columbia. Judge Chutkan, appointed by President Obama in 2014, has developed a reputation for being extremely well prepared, deeply knowledgeable about constitutional law, and absolutely unwilling to tolerate courtroom games or delay tactics. She's presided over numerous January 6 prosecutions and has consistently handed down tough sentences, making it clear she views the attack on the Capitol as a serious assault on American democracy. Reports from around November 7th revealed just how prepared Judge Chutkan was for the hearing that day. She didn't just show up with general questions. She had clearly spent hours, possibly days, meticulously reviewing every filing, every exhibit, every piece of evidence in the case. According to multiple reporters in the courtroom that day, Judge Chutkan opened the hearing by announcing she had specific questions about the factual record that need clarification before this court can rule on the pending immunity motions. Talk about setting the tone. Essentially, Judge Chutkan was signaling that she'd done her homework and expected Trump's lawyers to be able to defend their claims with specifics, not just sweeping legal theories. And this wasn't a casual inquiry during routine proceedings. Judge Chutkan made sure to frame these as critical questions that went directly to the heart of Trump's immunity defense, making it clear that how his lawyers answered could determine the entire trajectory of the case. This announcement created immediate tension in the courtroom because it raised all sorts of concerns for Trump's legal team. If Judge Chutkan was diving deep into the factual details, rather than just accepting their broad legal arguments about presidential immunity, what did that mean for their carefully constructed strategy of keeping the focus on abstract, constitutional principles instead of what Trump actually did? Now, this isn't the first time we've seen Trump's legal team struggle when judges force them to defend the factual basis of their claims. Trump's legal battles really only go smoothly when he can control the narrative through broad assertions and attacking his opponents. Whenever judges force his lawyers to provide specific evidence or defend particular factual claims, things tend to fall apart. We've spotted this pattern time and time again. Just think about how his lawyers struggled during the 2020 election challenges when judges asked for actual evidence of voter fraud. Rudy Giuliani and other Trump attorneys made sweeping claims in press conferences about the massive election fraud, but when judges asked them to present evidence in court under oath, they repeatedly had to admit they had no proof. In one Pennsylvania case, Trump's lawyer told the judge, "This is not a fraud case," directly contradicting what Trump and his team were claiming publicly. The lawyers knew they couldn't make false claims to a judge without risking sanctions or disbarment, so they backed down the moment they were held accountable. Then there was the pattern we saw with Sidney Powell. Trump's legal team wasn't pleased when Powell made wild claims about Venezuelan vote-changing algorithms and massive international conspiracies to steal the election. When Powell actually filed lawsuits making these claims, judges across the country dismissed them as baseless, and Powell eventually faced defamation lawsuits and legal sanctions. Trump quickly distanced himself from her once it became clear her claims couldn't survive even basic legal scrutiny. She went from being prominently featured at Trump press conferences to being disavowed as someone who was never really part of the legal team. And let's not forget how Trump's lawyers struggled in the classified documents case when Judge Eileen Cannon, despite being a Trump appointee, forced them to explain their legal theories in detail. Even a friendly judge required them to provide coherent legal arguments, and Trump's team repeatedly had to revise their positions when the actual law didn't support their initial claims. They'd file broad motions asserting Trump's rights, then have to walk back or modify their arguments when the judge asked pointed questions about legal precedent and statutory language. Even the January 6th cases involving Trump's allies showed this pattern when those facing charges initially defied subpoenas or made broad claims of privilege, but quickly cooperated once judges made clear they would be held in contempt. Steve Bannon ended up convicted of contempt of Congress. Peter Navarro similarly got convicted and ended up serving jail time the moment Trump's allies faced real legal consequences rather than just political theater. Their defiance crumbled. Now, it looks like Trump's current legal team is in the hot seat facing the same challenge. This pattern is becoming all too familiar. You can make all the confident assertions you want in press conferences and cable news appearances. But the moment a well-prepared judge asks you to defend those claims with specific facts and evidence under oath, the entire strategy falls apart. So what did Judge Chutkan do to trigger this emergency recess and courtroom freeze? Well, it all boils down to Trump's immunity claims and what actually qualifies as official presidential acts. The legal impasse in this case has centered on whether Trump's actions trying to overturn the 2020 election were official acts deserving of presidential immunity or were private political conduct for which he can be prosecuted. Trump's lawyers have been arguing for a broad interpretation of official acts, while Jack Smith's prosecutors have been trying to show Trump's actions were clearly outside the scope of official presidential duties. The case had already gone to the Supreme Court once, resulting in a July 2024 ruling that granted presidents some immunity for official acts but left many questions unanswered and sent the case back to Judge Chutkan to determine which of Trump's specific actions were official versus private. As the defense attorney in this immunity hearing, Trump's legal team decided to take a sweeping, aggressive stance. They filed extensive briefs arguing that essentially everything a president does while in office qualifies as official acts, refused to concede that any of Trump's election-related conduct was private, and pushed the position that even Trump's interactions with state officials and political rallies were part of his official duties to ensure election integrity. Their approach seemed to be just claim everything is immune and force the judge to rule against you on every point rather than making any strategic concessions. At first, this seemed to align with what Trump wanted. He appreciates lawyers who fight aggressively on every front, and the notion of broad immunity plays perfectly into his narrative that he's being persecuted for doing his job as president. But here's where things started to go wrong. As the November 7th hearing began, Judge Chutkan made it immediately clear she wasn't going to accept broad legal assertions without factual support. She started asking extremely specific questions about particular Trump actions, demanding to know exactly what evidence supported classifying them as official acts, and requiring Trump's lawyers to distinguish between Trump's role as president versus his role as a candidate seeking re-election. According to detailed reporting from Politico, published November 8th, Judge Chutkan zeroed in on Trump's phone call to Georgia Secretary of State Brad Raffensperger on January 2nd, 2021. This is the infamous call where Trump told Raffensperger, "I just want to find 11,780 votes, the exact number Trump needed to overturn Biden's victory in Georgia." Judge Chutkan asked Trump's lead attorney, John Lauro, a direct question: what official presidential duty was President Trump performing when he called a state official to pressure him to find votes and overturn that state's certified election results? Now, this left Trump's legal team in a genuinely difficult position. On one side, they needed to maintain their broad immunity claims to protect Trump from prosecution and satisfy their client's demand for an aggressive defense. Trump had made it clear he expected his lawyers to argue he did nothing wrong and everything he did was within his presidential authority. On the flip side, they actually had to answer a federal judge's specific factual question with a legally defensible answer. That means providing a coherent explanation of how calling a state official to pressure him about state certified election results falls within the constitutional powers of the presidency, and doing so without making arguments that would be obvious legal nonsense that could harm them on appeal. The tricky part is those two requirements are fundamentally in tension. So the more you claim that pressuring state officials about election results is an official presidential act, the more you're arguing for an imperial presidency with virtually unlimited power. But if you concede that some of Trump's actions weren't official acts, you've opened the door to prosecution on those counts and admitted your immunity defense has limits. So Trump's lawyers are caught in a bind. They can either stick with the maximalist position that everything Trump did was official, which means trying to explain to a skeptical judge how pressuring state officials to change vote counts is an official presidential duty, and that makes them look like they're defending indefensible conduct and risks the judge finding their arguments frivolous, or they can make strategic concessions and admit some of Trump's actions were private conduct, which means acknowledging parts of the prosecution's case are valid and potentially exposing Trump to conviction on those counts. But that'll definitely make Trump furious because he views any concession as weakness and betrayal. Here's where it gets really interesting. According to reporters who were in the courtroom, John Lauro began his answer by stating that the president has constitutional authority to ensure the integrity of federal elections. Judge Chutkan immediately interrupted, "Counselor, I didn't ask about federal elections generally. I asked specifically about the Georgia call. What constitutional authority empowers a president to call a state secretary of state about state certified results in a state election?" And Lauro attempted to pivot, arguing that state elections determine federal office holders, so the president has an interest in their integrity. But Judge Chutkan wasn't having it. She pointed out that states have constitutional authority to run their own elections. The president doesn't have supervisory authority over state election officials. So ask again, what official presidential duty was being performed in that call? This is the moment everything started to fall apart. Lauro requested a moment to confer with co-counsel, which is unusual in the middle of answering a judge's question. After a brief whispered consultation at the defense table, Lauro asked if they could address the court's question in the context of the broader factual record. It was clear the legal team was stalling, trying to avoid giving a direct answer that would either admit the call wasn't an official act or make an absurd argument that could haunt them on appeal. But then Judge Chutkan dropped the hammer. She said, "Counselor, I've reviewed the transcript of that call. President Trump didn't ask Mr. Raffensperger about election integrity procedures or federal concerns about voting systems. He asked him to find specific votes, the exact number needed to change the election outcome in Georgia. He threatened Mr. Raffensperger with criminal consequences if he didn't comply. He made false statements about the vote count. Can you point to anything in that conversation that relates to an official presidential function rather than candidate Trump's desire to win Georgia's electoral votes?" The courtroom went dead silent. According to multiple reporters present, you could have heard a pin drop. This wasn't a general legal question Trump's lawyers could answer with broad constitutional theories. This was a specific factual question about a specific recorded conversation, and Judge Chutkan had clearly studied that conversation in detail and knew exactly what was in it. Trump's lawyers were being asked to defend the indefensible, to explain how Trump asking a state official to fabricate votes was somehow an official presidential duty. John Lauro stood at the podium for what witnesses described as an uncomfortably long pause. His co-counsel was frantically flipping through documents. The entire defense team looked like they had just realized their D walked into a trap they should have seen coming. Finally, Lauro said something that shocked everyone in the courtroom. Your Honor, this specific question touches on matters we may need to consult with our client about before providing a definitive answer. We request a brief recess to confer. A federal judge had asked a straightforward factual question about evidence in the case, and Trump's lawyers couldn't answer it without talking to Trump first. Think about what that means. Either they didn't have a prepared answer to an obvious question about one of the most publicized pieces of evidence in the case, or they had an answer but knew Trump wouldn't approve of it, or they realized any honest answer would be devastating to their case. None of those options look good. Judge Chutkan's response was measured but clearly unimpressed. Counselor, you've had months to prepare for this hearing, and this call has been part of the indictment since day one. But I'll grant a 15-minute recess. When we return, I expect specific answers to specific questions, not generalized legal theories. The courtroom erupted in whispered conversations the moment the judge left the bench. Reporters were texting their newsrooms. Jack Smith's prosecution team was exchanging looks that seemed to say, "Did that just happen?" And Trump's legal team was huddled in an intense, clearly strained conversation. This whole scenario is causing major stress within Trump's legal and political operation. If Trump's own lawyers can't answer basic questions about key evidence without an emergency recess and consultation with their client, every Trump ally is left wondering if this case is even defensible. Those more moderate voices around Trump who are trying to balance legal reality with political loyalty are now worried sick about heading into trial with a team that appears unprepared for predictable questions. They know that getting caught flat-footed in a pretrial hearing is terrible optics, suggests poor case preparation, and indicates the defense strategy might collapse under sustained judicial scrutiny. Meanwhile, the Trump loyalists who believe the entire prosecution is a political witch hunt are doubling down. They believe the lawyers should have just attacked Judge Chutkan's authority to ask such questions, claimed she's biased, and turned the hearing into political theater rather than trying to provide actual legal answers. They're pushing for Trump to replace his legal team with lawyers who will be more confrontational and less concerned with traditional legal strategy. Things became even more intense when reports emerged that during the recess, Trump himself called into the courthouse on his lawyer's cell phone. According to CNN's as reporting from sources familiar with the situation, Trump was furious that his lawyers had requested a recess, viewing it as a sign of weakness. He reportedly wanted them to refuse to answer the question and to attack the judge for bias. Instead, this created an impossible situation for the lawyers. They had to return to the courtroom in minutes with an answer. Their client wanted them to be confrontational in a way that could get them sanctioned, and they knew any substantive answer to the judge's question would undermine their immunity claims. When someone as focused on never admitting wrongdoing as Trump starts directly interfering in courtroom strategy during a hearing recess, the legal team has lost control of the case. The lawyers are supposed to be the experts guiding the strategy, but instead they're taking orders from a client who has no legal training and whose primary concern is political optics rather than winning the case on legal merits. Now, the 15-minute recess stretched to almost 30 minutes, which is itself significant. When the hearing resumed, according to detailed accounts from NBC News reporters in the courtroom, John Lauro's entire demeanor had changed. He appeared more tense, less confident, and his answer to Judge Chutkan's question was telling in what it didn't say. Lauro stated, "Your Honor, the defendant's position is that all actions taken by a president in connection with their constitutional duties, including ensuring election integrity, are entitled to immunity." The Georgia call was part of President Trump's broader efforts to investigate election irregularities that had been reported to him. Notice what he didn't say. He didn't explain how calling a state official to find specific votes is an official duty. He didn't address Judge Chutkan's point about the president lacking authority over state election administration. He didn't engage with the actual content of the call, the threats, the false statements, the specific request for exactly enough votes to win. Instead, he retreated to the broad legal theory the judge had already indicated she wouldn't accept without factual support. Judge Chutkan's response was swift and devastating. "Counselor, that's a legal conclusion, not a factual explanation. The question before this court isn't whether presidents generally have some role in election integrity. The question is whether this specific call asking a state official to find a specific number of votes to overturn a certified state election result is entitled to immunity as an official act. Your answer suggests you cannot identify an official presidential function that was being performed. Is that correct? Another long pause. Then Lauro made what legal experts immediately recognized as a strategic retreat. Your Honor, we would ask the court to consider the totality of circumstances and President Trump's understanding of his constitutional obligations. Will address this more fully in supplemental briefing if the court requires it. That's lawyer speak, for we don't have a good answer. We need time to come up with something, and we're hoping you'll move on to another topic. Judge Chutkan didn't move on. She spent the next 20 minutes systematically walking through other Trump actions outlined in the indictment: the fake electors scheme, Trump's pressure campaign on Mike Pence, his tweets attacking election officials, and asking similarly specific questions about how each one qualified as an official presidential act. On each question, Trump's lawyers gave similarly evasive answers, retreated to broad legal theories, or requested the opportunity to brief the issue in writing rather than answering directly. Legal experts watching the hearing were stunned. Andrew Weissman, a former federal prosecutor who served on the Mueller investigation and is definitely experienced in high-stakes legal proceedings, tweeted during a break in the hearing, watching a defense team unable to answer predictable questions about their core. Legal theory is extraordinary, so these aren't surprise gotcha questions. This is the heart of the immunity claim they've been making for months. If you can't explain it in court, you can't win it. George Conway, a conservative attorney who's been a vocal Trump critic, appeared on MSNBC that evening and stated, "What we saw today was a legal team that has been making arguments in the court of public opinion that simply don't hold up to judicial scrutiny. When Judge Chutkan asked them to defend their claims with specifics, they had nothing. That emergency recess was essentially an admission that they're not prepared to defend their own case theory." Even more telling, Jonathan Turley, a George Washington University law professor who has often defended Trump's legal positions and appeared as a Republican witness during Trump's first impeachment, wrote in a blog post that night, "The defense team's performance today raised serious questions about their case preparation. While presidential immunity is a complex constitutional question, the defense should have anticipated being asked to distinguish official from private conduct, and that they seemed unprepared for this line of questioning is concerning." When legal commentators from across the political spectrum, from Trump critics to Trump defenders, all agree that his legal team performed poorly and appeared unprepared, that's a significant red flag for the defense. So let's break down what this courtroom disaster could mean, because it's not just about one bad hearing or one awkward moment. It has serious consequences for Trump's entire legal strategy and his political future. First up is the immediate legal fallout. Trump's immunity defense, the cornerstone of his entire strategy in this case, just got exposed as far weaker than his team has been claiming. They've spent months arguing that Trump's actions were official presidential acts entitled to immunity, but when forced to defend that claim with specifics, they couldn't do it. Judge Chutkan now knows their legal theory has no factual foundation. She's seen them unable to answer basic questions about their own defense. That makes it extraordinarily unlikely she's at a rule in their favor on immunity. And honestly, that's devastating for Trump's legal prospects. His entire strategy has been built on delaying the trial by litigating immunity questions through multiple levels of appeal. But if Judge Chutkan issues a detailed ruling rejecting the immunity claims and pointing to the defense team's inability to provide factual support for those claims during the hearing, that creates a much stronger record for the prosecution on appeal. Appellate courts give significant deference to trial judges' factual findings, especially when those findings are based on courtroom proceedings where the judge directly observed the lawyer's inability to support their arguments. The optics are equally terrible. Every major news outlet covered this hearing, and the headlines all focused on Trump's lawyers being unable to answer the judge's questions and requesting an emergency recess. Trump lawyers stumble. Defense team caught unprepared. Emergency recess after judge. S questions stump Trump attorneys. These stories write themselves, and they're all terrible for Trump. For someone who obsesses over looking strong and winning, having your own lawyers appear weak and unprepared in court is about the worst possible narrative. Now, let's touch on what this means for Trump's legal team itself. There's clearly dysfunction and poor coordination within the team. The fact that they weren't prepared for obvious questions about the most publicized evidence in the case suggests either inadequate preparation or strategic disagreements that prevented them from developing coherent answers. The emergency phone call from Trump during the recess, if confirmed, indicates he doesn't trust his lawyers to handle the case without his direct intervention, which is itself a sign of a dysfunctional attorney-client relationship. We're likely to see more turnover on Trump's legal team. He's already burned through multiple legal teams across his various cases. Todd Blanche has taken on the lead role in multiple cases. Boris Epshteyn, despite not being a practicing attorney, has a huge influence over legal strategy, and several high-profile lawyers initially associated with Trump's defense have quietly stepped back or been pushed out. When a legal team performs this poorly in a high-profile hearing, it's only a matter of time before Trump starts blaming them publicly and looking for replacements. But here's the problem. Trump's running out of experienced lawyers willing to take his cases. High-quality defense attorneys are increasingly reluctant to represent him because he doesn't pay bills. He doesn't follow legal advice. He attacks his own lawyers publicly when things go wrong, and he pressures them to make arguments that could get them sanctioned or disbarred. The lawyers willing to represent Trump at this point tend to be either true believers who prioritize loyalty over legal judgment or less experienced attorneys who see it as a career opportunity despite the risks. Neither category includes the kind of battle-tested, strategic thinkers Trump desperately needs. This situation shines a massive spotlight on the fundamental weakness of Trump's legal position. At its core, the problem isn't that Trump has bad lawyers, though his current team's performance was certainly poor. The deeper problem is that Trump's actions are legally indefensible. There's no good answer to Judge Chutkan's question about the Georgia call because there is no legitimate official presidential function that involves calling state officials to pressure them to fabricate votes. The reason Trump's lawyers couldn't answer the question isn't incompetence, it's that any honest answer destroys the immunity defense. This is the same pattern we saw in the 2020 election lawsuits. Trump's lawyers made bold claims in public, but when judges asked for evidence, they had to back down because the evidence didn't exist. You can't prove election fraud that didn't happen. Similarly, you can't explain how criminal conduct qualifies as official presidential duties because it doesn't. The legal theories Trump wants his lawyers to advance are fundamentally flawed, and they fall apart the moment a judge examines them closely. So the implications of this hearing reach far beyond just this one case. It's revealing the emperor has no clothes when it comes to Trump's legal defenses. Each time Trump's lawyers get exposed as unable to defend his actions in court, it weakens the broader narrative that he's being persecuted. It starts making it clear that the problem isn't biased prosecutors or partisan judges. The problem is that Trump's conduct was actually illegal and his defenses are meritless. Think about it. If Trump's best legal minds, armed with unlimited resources and months of preparation, I can't answer a judge's straightforward question about key evidence, what does that tell you about the underlying case? If Trump's lawyers have to request emergency recesses to figure out what to say, what does that suggest about the strength of their legal position? If they can't distinguish between official presidential acts and private political conduct, even after the Supreme Court remanded the case for exactly that determination, what are the chances they'll prevail at trial? These aren't hypothetical questions anymore. Every judge, every prosecutor, and every potential juror watching these proceedings is drawing the same conclusion. Trump's legal defenses are collapsing under scrutiny, and his legal team knows it. That's why they're stalling, evading questions, and requesting recesses because they have no good answers. Looking ahead to the trial itself, this hearing was a preview of what's coming, and it doesn't look good for Trump. If his lawyers can't handle a pretrial immunity hearing without falling apart, how are they going to handle weeks of trial with Jack Smith's team presenting evidence, witnesses testifying about Trump's conduct, and Trump himself potentially taking the stand? Every weakness exposed in this hearing will be magnified tenfold at trial. The prosecution now knows exactly where Trump's defense is vulnerable, and they'll exploit those weaknesses ruthlessly. So expect the prosecution to focus heavily on the specific actions Judge Chutkan asked about. The Georgia call, the fake electors, the pressure on Pence, they'll present detailed evidence about each one, forcing Trump's lawyers to either defend the indefensible or admit Trump's actions were wrong. Either choice leads to conviction. If the lawyers try to defend the conduct, they'll look like they're endorsing criminal behavior. If they admit the conduct was wrong but claim Trump didn't know better or was misinformed, they're essentially admitting guilt and hoping for leniency. The trial will also expose Trump to sustained factual scrutiny in a way he's never experienced. In political rallies and social media, Trump can make any claim he wants, and his supporters will believe it. In friendly media interviews, he can dodge tough questions or attack the interviewer, but in a courtroom, he can't control the narrative. The prosecution will present evidence, witnesses will testify under oath, and Trump will have to answer for his specific actions with specific defenses. There's no spinning, no deflecting, no running away. So here's the deal. Trump's lawyers just got exposed in federal court as unprepared, unable to defend their core legal theory, and so desperate they had to request an emergency recess during oral arguments. This isn't just an embarrassing day in court. It's a fundamental exposure of the weakness of Trump's entire legal position. If Trump's own lawyers can't explain how his actions qualify for presidential immunity, then the immunity defense is effectively dead. That means the trial is almost certainly going forward. And Trump will have to face a jury with a defense strategy that just collapsed in front of a federal judge. It's about so much more than just whether Trump's lawyers had a bad day. It's about whether Trump can be held accountable for his actions or whether he can delay and obstruct long enough to escape justice. The courtroom freeze we witnessed wasn't just an awkward pause, it was the moment Trump's legal strategy fell apart. So keep an eye on this. Things are moving fast now. Judge Chutkan has seen through the immunity claims. Trump's lawyers are in crisis mode, and the prosecution smells blood in the water. The next few weeks are going to be absolutely crucial. We're just getting started. The stakes have never been higher, the defense weaker, and the path to trial clearer. This ride is far from over, but Trump's legal team just lost control of the wheel.